Well, hello everyone, and welcome to today's program, Space Law 101, what attorneys need to know about the legal framework governing commercial space activity. I'm Ala Policastro, Director of Education and Professional Development at Beverly Hills Bar Association, and today I'm delighted to introduce our speaker, Mary Christine Sungaila. Mary Christine teaches space law and policy at Loyola Law School in Los Angeles. She is a partner at Complex Appellate Litigation Group, where she has briefed or argued more than 170 appeals spanning complex and cutting-edge issues across a range of practice areas. She has handled matters before the U.S. Supreme Court, multiple state Supreme Courts, numerous federal and state appellate courts, and the Inter-American Court of Human Rights. Mary Christine has twice won the California Lawyer of the Year award, along with other top industry honors. She has written numerous articles on appellate practice and contributes to leading appellate treatises and trial handbooks published by the ABA and the CEB. We can't wait to hear what she has to share with us today, so I'm going to turn it over to her.
Thank you so much. Really appreciate that introduction. And some of you may be wondering, hey, there's a lot of appellate law in there. What did I hear about space law other than space law and policy professor at Loyola? And how am I doing that? So I also have an LLM in Air and Space Law from the University of Mississippi, Center for Air and Space Law. And I also am a private sector advisor to the Department of State, the U.S. Department of State, and also I'm a delegate to the UN COPIUS, which is the kind of international rulemaking committee for international space law. So today the focus is on really just an understanding of the framework of space law and applying it to potential disputes and questions with regard to commercial space, as well as licensing commercial space activity, at least in the United States. So it'll be a tour of international law, a little U.S. domestic law, and then some sort of hot issue areas in space law, like space mining, orbital debris, and the like. So I want to first mention on the slide, this is a picture taken by the first successful private commercial moon lander, which is Firefly's Blue Ghost, which happened last year. So it's just this picture sort of symbolizes the rise of commercial space activity, private commercial space activity, and the role that it will have in space, on the moon, and elsewhere. So next slide, please. Thanks. So also I wanted to point out that the questions of space law are particularly relevant if you are in Southern California, and commercial space questions in particular. I have on the screen just a few of the companies which are really leading national and international companies that have either their headquarters or some kind of presence in Southern California. On the bottom, you'll see Boeing, Northrop Grumman, Lockheed Martin. These are the traditional big prime commercial space companies that you may have been used to seeing since the 1960s in Southern California. That's sort of the original layer of commercial space and aerospace industry in our area. And then the rest of them are the new era. So Rocket Lab and SpaceX. Rocket Lab is the second most frequent launcher in the world behind SpaceX. They're a much smaller rocket company, but they are doing quite well. Relativity is involved in 3D printing of space objects. VAST is building the world's first private commercial space station and is competing for that role and probably is doing quite well in that competition. Turian Space is a satellite company. Anduril and True Anomaly are the next vanguard, I would say, of deep tech and space defense. So you may have heard about a lot of spending on the Golden Dome and various discussions of US policy with regard to the militarization of space. And there's a lot of government money to be spent on those kinds of objects, and Anduril and True Anomaly are among the leaders in that regard. Then Astroforge is one of the space mining companies. So there are a couple of space mining companies either looking to mine asteroids for precious metals, or also possibly mining the moon for also helium-3 potentially, or also other kinds of rare earth minerals and things that are much harder to get on Earth, but are more readily available on the moon. All right, next slide. So I mentioned some of this in the beginning, but I just kind of want to give the overall takeaways, I think, from this particular program. And the first one is I'm covering both international and domestic laws for a reason, which is that you cannot fully understand even your own domestic space law if you do not understand all of the interlocking pieces that go with that, which is the international and the domestic. And that is a truly unique feature of space law. Most of us would say we had really interesting international law classes in school, but never had occasion to use that, unless you're doing international deals or some kind of international arbitration or something. But in the space context, you need to know that, understand what's going on at the international level, because through treaty language, it's a direct throughput to the domestic laws. So you have to understand all of it, how it's moving, how it's operating at any point in time. And I will say, as I tell my students at Loyola, when they ask me, could you please stop changing our syllabus reading every week? Couldn't we just know what we're supposed to read each week? To which I say, well, if it were like property or rule against perpetuities, or something where the law is quite old and really not changing significantly day to day, that would be possible. But that is not where we are in space law. It's constantly changing at the international level, at the domestic level. New activities are happening, new regulations are being made. So it's a dynamic, and the dynamism is in the interaction between the international and domestic, as well as at the international and domestic levels individually. And then the next takeaway, I think, is this new frontier aspect, which obviously space as the new frontier. If anyone has watched Star Trek, that's always the opening line. But there are also new frontiers in the types of activities. So the area of space used to really be just governments perhaps contracting with their traditional contractors like Boeing or Northrop Grumman for various, government bespoke space objects, but that's no longer the case. The commercial actors themselves are doing a lot of new and interesting things. And what we can do in space and the value that space can bring back to Earth is changing. So some of these examples are microgravity research. So researching and formulating the building blocks of drugs in space, in lower Earth orbit. There are certain things that you can do in microgravity or zero gravity that you cannot do on Earth. And therefore, there are a lot of drug companies already who have been doing work on the International Space Station, formulating crystals, doing their building blocks of pharmaceuticals, and they've been able to expand the number of diseases they have been able to treat. I think one of the most notable ones is Keytruda, which, as formulated on Earth, can address certain types of cancer, but when formulated in space, can actually address several more types of cancer. So there's a potential for expansion of drugs that already exist into new uses, but also being able to do research and manufacture things that you just could never dream of doing on Earth. So that's a direct benefit, obviously, to humans on Earth. But then there's also a significant number of lunar activities being planned. So everything from nuclear power in orbit and also on the moon. So if you can dream it, it's happening either right now or in the next 10 to 20 years. As I'll move on to the third point here, which is industry is growing and innovating, but also there are the geopolitics of space, which never really disappear in figuring out where we're going to go next. We're in a second space race. If you haven't heard the rhetoric about this, it was the US and Russia before, and now it's US and China. So a race to get to the moon, in part to find a spot that might be the most advantageous spot to operate from, and also to be the first so that we can start setting the rules of the road and governance on the moon and in space overall. So the geopolitical challenge, the geopolitical fight for supremacy in space is on once again, and that fuels government funding for new programs, and it fuels commercial space industry in large part too. So there's a feedback loop that's in hyperdrive right now. So that means that we need to move quickly to make sure that some kind of space law and governance moves maybe at least at the half-life of the activities of these companies, which are quite fast-moving. All right, so let's dig into it. The next slide, please. So I said I'd start with the international law, and there are five, we call them the big five space treaties. Because as I mentioned, until very recently, really space activities were purely the province of governments. Only governments had the money and the resources to either, launch or procure the satellites, and certainly to send people as far as the moon. So as a result of that, and as a result of actually the Cold War tension between US and Russia, the entire world thought we really should get some guidelines in place, because there was a concern that amongst with this race between the United States and the Soviet Union, that perhaps we might put some weapons of mass destruction above the earth, and that would be bad for everyone. So we wanted to have some rules of the road for that. And so that was really the birth of the Outer Space Treaty in 1967. There's actually, you see a flurry of many of the treaties, 67, 68, 75. All of these were in short order of each other because there was a sense of urgency from both the United States and the Soviet Union having this interest in the space race. And so there was a lot of, let's get moving on this. So the Outer Space Treaty is really the Magna Carta. It's the constitution of space law. It is really the fundamental governing principles for space activities, including non-appropriation, peaceful use, responsibility, and liability. And I'll get into that in a little more detail later. And then these other agreements largely flesh out some of the provisions in the Outer Space Treaty. So how you treat astronauts and how you treat space objects that may have landed in the wrong part of Earth or have been stranded in space. Registration convention, we got to know whose space object is out there. How do we do that? We register them on our domestic registries, and we also register them with the United Nations. And I'll say the registration is important for a couple of different reasons. One is that whoever launches or procures the launching of a space object, that continues to remain within the jurisdiction of whoever the launching state is, or the owner of the original launched object if it's launched from another country. So you need to know, okay, that whoever owns it, that's which particular jurisdiction or law to some degree is applying to that object. but also who's responsible, who continues to be responsible for that object. Under the treaties, once you've launched it and put it out there, you can't just abandon it, although people do sometimes, but you're not supposed to. You retain responsibility over that object and retain liability if it were, for example, to crash into a bunch of other satellites and destroy them. So registration seems mundane, but is an important building block. And then the liability convention fleshes out and adds to the Outer Space Treaty's description of liability and responsibility, and establishes a multi-tiered liability system for damage caused by space objects. So those really are the top four that there's overwhelming agreement to, an overwhelming amount of signatories. The Outer Space Treaty has 118 signatories, so there's a lot of agreement there. The Moon Agreement, I think, has about 20 signatories, so it's kind of the stepchild of the other agreements. And the U.S. And a lot of other major spacefaring nations have not signed on to the Moon Agreement. And there's a reason for that in terms of it talks about if you're going to mine or take natural resources, that those do not become the property of any state or entity. And as I mentioned, space resources is a major potential source of minerals and of other things that we might want. And the United States, understanding how commercial space companies operate, if they could not keep their resources that they mined, then why would they create a company and invest all the money that's necessary to go mine something if they can't get any profit from it? And so those who have a deep interest in space resources and fostering that kind of activity will not generally be signatories to the Moon Agreement. All right, next slide, please. So I want to kind of briefly go over the Outer Space Treaty because it sets the rules of the road in terms of how we understand space, and sort of the overall rubric in which we're operating. There's a lot of gray areas in this as well, a lot of things for lawyers to chew on and to think about, but it's important that you understand this framework from which other things flow. So first is this principle of peaceful exploration. Outer space shall be used for peaceful purposes only. You might say, hey, I heard you say something about Golden Dome and the military being out in space. How does that square with peaceful purposes? And the answer is that varies over time. So previously, there was really not a sense of militarizing within space, beyond cislunar space, with the vigorousness that we're looking at it now. But we also did not have as deep, I'll say as deep a bench of commercial space companies who were going as far as they are at this point, going to the moon and going potentially to Mars. So there's a lot more activities, there's a lot more scope for that. And, just like the Coast Guard, the Merchant Marine, we want to protect those activities, as well as understanding that some of the activities that are going on in space are not without military use or dual use as well, whether you're talking about satellites that can do remote sensing on Earth for national security reasons, as well as for commercial reasons. So there's always been some military presence in space that's changing, and so peaceful purposes depends on who you talk to about what's allowed within that. This is really an important principle because it deals with jurisdiction and what kind of power we have to claim things in space. So the no appropriation principle. So no sovereign can claim part of a celestial body or outer space. So whoever gets to the moon first, US or China, cannot say, now I own the moon, because sovereigns cannot do that under the Outer Space Treaty. It does not mean that you cannot have bases on the moon, that you cannot have military bases that serve peaceful purposes and scientific research. So there's, as we learned in property law, there's a bundle of rights within property, even if you don't outright own that property. For example, you may not own the land on which you are mining on the moon, but you can own what you extract from the moon. So, so this no appropriation principle is also getting stretched and tested, given some of the new activities. Environmental protection. We try to avoid harmful contamination. Don't bring anything bad or hurtful to celestial bodies, and also try not to bring anything back to our planet. The planetary protection of Earth as well. And then liability. So who's responsible for what? Countries are liable for national space activities. Now, this is important whether carried out by the government or carried out by a non-governmental entity. So this is a really important one that's coming into play with commercial space now, because, okay, well, maybe the government and the treaty obligations, they kind of, diminish or don't become important once we have all these commercial actors, because they're not bound. They're not a government bound by the treaty. This was actually a key point of debate at the time of the Outer Space Treaty. The two space powers at the time basically got to hammer out what was acceptable to them to be in the Outer Space Treaty. Russia's position was that there should never be any private commercial space actors in space. Everything should be the government. And the United States saw the future and saw that private actors would be in space and private companies would be in space, and they wanted to leave that opening for it. So the compromise for that is Article 6 of the Outer Space Treaty, which talks about authorizing and continually supervising the activities of these private space companies. Next slide. So I want to get to that because that's an important question here. So, and actually there's a bunch of debate about what this actually means, because of course we're lawyers, we can debate a lot of things. And also, frankly, we haven't had these same kinds of activities in the past. And so certain scenarios are kind of testing the limits. So we are, state parties to the treaty are responsible for national space activities, again, whether carried out by government or non-governmental entities. And the state parties must authorize and supervise non-governmental entities. So you have to authorize it, which largely means licensing. You have to license the launch or license the particular kind of activity, or at least have some kind of authorization or oversight over it. And then you can't just leave it there, having licensed it, and say, have a good life. The government's no longer responsible to do anything. That's the supervision part of it. How much you have to do, how much supervision you have to do, what that looks like is actually something that is evolving and emerging right now. There are many different views with regard to Article 6 itself, what it means, how broad it is, what the language means. State parties to the treaty shall bear international responsibility for national activities in outer space and for assuring that national activities are carried out in conformity with the provisions set forth in the treaty, and whether those activities are carried out by government agencies or non-governmental entities. So that's Article 6 language, but what does that exactly mean? And there are varying interpretations of this going on actually right now. In the last year, there are at least 3 different views about this, like how much government oversight is actually required by Article 6, and how much leeway do you have for that? Some people say, well, it's really, and this is the traditional view, it's a very broad set of responsibility and attribution. This provision of Article 6 applying to non-governmental entities, especially given the drafting history between US and Russia, is really meant to say that non-governmental private commercial space companies are essentially, through the state, subject to all of the provisions of the Outer Space Treaty and other international laws that would apply to government actors in space. So in other words, it's completely equivalent and very broad. There's a narrower interpretation saying, no, I don't think it's that broad. It is a narrower sort of customary law attribution. It is not as broad as the traditionalists have said. And then there's a third view that says, well, what does supervision mean? It might just be a really, really minimal procedural supervision, like renewing licenses. Once you've authorized and licensed an activity, just like any other license renewal, you kind of look at it not super deeply unless there is a particular problem, unless something has collided with something since the license was granted, or something bad has happened that wasn't taken into account in the earlier licensing. So those are sort of three different developing views, I will say, of commentators. And in the international realm, part of how you build up international law is academic thought like this. So a really influential law review article, like the three that I just spoke about, are currently being debated and currently could have an impact on ultimately where we go. I'll say there's another view of this, which is partly where I come out, but also where it appears that our US Department of Commerce is coming out, which is having an adaptable system. In other words, the more risk that your activity has, if it's a novel risk, or novel activity with new risks that we haven't really vetted, then perhaps there should be more supervision and more stringent licensing procedures and authorization. If it's launching a satellite into LEO, which we have done for decades, perhaps we don't have the same kind of supervision requirements. So that's that. All right. So also I mentioned there's this second treaty, the Liability Convention. So there's two ways to have a state responsible or liable. One of them is the responsibility provision of the Outer Space Treaty, and the other is this Liability Convention. Liability Convention is more drawn out. It is the only treaty with regard to space law that really sets out, it has its own notification procedure, its own claims procedure, its own claims commission that can be created for a particular dispute. And it lays out tiers of liability based on whether the space object has caused problems to aircraft near Earth or to the surface of the Earth, or whether it's space object to space object, so a satellite hitting another satellite. And that also lays out a really broad set of compensation, essentially a sort of restitution principle. So there's this, and then there's the responsibility provision of the Outer Space Treaty. So there were initially some questions. How do these interact? In other words, are they mutually exclusive? Do you have to choose just liability, or is there actually a separate responsibility aspect? And that is really Article 6. Article 7 of the OST is the one that talks about the part that's fleshed out in the Liability Convention, that each state party to the treaty that launches or procures the launching of an object into outer space, and each state party from whose territory or facility an object is launched, which actually could be many different countries. So you could have, a US rocket or Japanese rocket that is, for whatever reason, launching from Africa. And in that case, you'd have a number of responsible parties. The state that was responsible for the rocket and that owns the space object, and then the territory from which it was launched, whatever country in Africa. So, any and all of those are internationally liable for damage to another state party to the treaty or to its people by this object or its component parts on Earth, in air, or outer space, including the moon and other celestial bodies. So this liability part, this liability convention and Article 7 of the OST have an impact on sort of things raining back down on Earth. I don't know if you've seen recent news reports, but space junk falls to Earth all the time, sometimes in places that are less populated, sometimes actually into people's homes. There were some folks in Florida who had part of a space object crash through their roof. So this will become more important as activities continue on. So next slide. We have had no invocation of either of these treaties, so except for one. And this was the Cosmos 954 satellite crash in Canada. So it's a nuclear-powered satellite crashed in the beautiful wilds of Canada in 1978, strewing out all of its radioactive aspects throughout this wilderness. And Canada's pretty upset about it. They have to clean it up. They have to investigate it. And so they filed a claim against Russia for the damage from this satellite crash. And no one had ever filed any claim under any of these treaties before. So we're just sort of figuring that out as we go. So Canada pled in the alternative. They pled the liability convention. They pled the OST responsibility, and they sought $6 million from the Soviet Union, and they invoked this claims procedure and claims commission under the liability convention that gives them at least a place to go for that particular claim. The OST didn't have a place to go. It doesn't talk about a dispute mechanism. And so the first thing you have to do in all international incidents is exercise diplomacy and discussion. And so they sent this letter saying we have this claim to Russia and we invoke this right to the Claims Commission. But the Claims Commission actually never got stood up or decided anything because Russia decided to pay Canada at least $3 million, half of their $6 million that they wanted for that cleanup. But at least it does show that Russia at least thought that, hey, whether probably the liability convention, because it has quite broad damage definitions, it's probably they believed that Canada had a good claim under that, and that the commission was stood up properly for that. But it also can be interpreted that Russia thought, well, alternatively, they might also have this responsibility claim. And so that's important because it's at least a principle showing you can plead either one of these in alternative if you're a country. So next slide. What do you do if you're like the homeowner and something falls in your roof? Do you go to the Claims Commission? Well, you're not a country, so you can't do that. And you could potentially have your government interact with the government who that's responsible for the space object that fell through your roof and figure out some kind of consultation and diplomacy. But maybe our country has other interests with that country that, they don't want to work on the thing that fell through your roof. They're working on other more important national security issues with that country. They really don't want to bring it up. So if you're not the government, you can't have that. What do you do? This Claims Commission, for example, under the Liability Convention, understandably, is only between countries because that's who can sign treaties. So what do we do with this? I'll talk about some domestic disputes a little bit later, but in this context where you have many actors, you have many different governments in space as well as private actors, what do we do with this? And right now, there is, other than the ICJ and a permanent court of arbitration, which has a specialized space arbitration panel, which has never been used and never been invoked. There really isn't anywhere for these sort of mixed disputes between private folks and various governments to go. And so recognizing that and the need for having a place to go for disputes as contributing to the stability of a commercial space endeavor, the United Arab Emirates has been quite entrepreneurial in this regard. They have announced creation of a number of courts in their DIFC, which is a financial center. It's a carve-out jurisdiction out of the rest of the UAE, where if you have other kinds of business disputes, you can bring them to those courts, generally really arbitration type courts, but at least you have a place to go to bring your disputes. And so one of these DIFC courts are the space courts, which have not yet been stood up, but they're working on having judges schooled in space law and having space law specific rules for those courts. So they're not operational yet, and therefore no one's invoked them. But it's the idea that somebody's seen a gap and is trying to fill it. All right, next slide. I wanted to touch on this briefly too, because I mentioned the geopolitics of space, which is we have treaties internationally. We also have non-binding principles that the United Nations, UN COPIUS, has on nuclear power, on remote sensing, on orbital debris mitigation, all of these things that are non-binding, but nonetheless setting at least some kinds of standards. And the Artemis Accords, which is an interesting approach that the United States has taken. So these were originally agreements between various space agencies around the world. There's now actually 67 signatories to the Artemis Accords. And so the Accords, they're not a binding treaty, they're not a UN document, but they are an expression of how we will govern ourselves, how we will work with each other in our space exploration. And of course, the interest in signing on to this is large part people want to work with NASA, they want to work with the United States on space activities. And if you want to do that, you really should be a signatory to the Artemis Accords. And it does not replace, obviously, the Outer Space Treaty and does not conflict with the Outer Space Treaty, but it does start operationalizing some of the perspectives that the United States and the 66 other nations have about how we should conduct ourselves in space. Most notably, this resource extraction question. We should share data and notify each other of extraction activities, but we can do them. And and our people can keep whatever they resource. And also this concept of safety zones. So figuring out how do you operate on a finite surface like the moon in some finite areas where many people will want to be. There are certain areas that are rich in minerals, are rich in certain things that we will want to extract. And so it's going to get a little crowded. So how do we operate with each other when none of us can actually own that land? And so this concept of safety zones, of saying, while you need to do certain activities, kind of people cannot just freely access it. Once we're done with that activity, you can come through again. This idea, sort of starting out, this idea of safety zones really comes from the Artemis Accords, as does protection of cultural heritage. So I'll talk about that a little bit further, but the Artemis Accords are really, at this point, the only international instrument that recognize the value of protecting heritage, like our Apollo landers. So, okay, next slide. So I mentioned this is all of the international framework, which is in play, right now in terms of operationalizing and adapting, but also we have our own space laws and our own space policy. So obviously we were one of the original space powers, and so our laws are a bit vintage that we're layering onto. It also creates a problem for licensing. As each space activity came up, we assigned an agency to license or regulate it, and so now we have a patchwork of agencies that are licensing and regulating different parts of space activities that make it quite a bit unwieldy for commercial companies to navigate. So anyway, so here's some overview of some of our national laws, and I would say national policies. So establishing NASA and our civil space activities and scientific research, like the Artemis 2 mission that just returned from the trip around the moon. We have a series of commercial space launch competitiveness acts from the 1980s through to 2015. And the 2015 act is the one that clearly said that space resources, once extracted, can and should remain part of, that the companies that do that can own it and sell it. On top of that is this layer of space policies. So there are also space policies that are coming out of the executive branches, out of the White House, out of other parts of the executive branch. And all of these policies for a very long time have supported commercial space, have said commercial space, supporting the viability of commercial space is actually a policy of the United States. It is something that we deem important for our national security and space competitiveness. And there is nowhere where this is more pronounced than the December 2025 Ensuring American Space Superiority Executive Order. It is literally the first integrated space policy across civil, commercial, and military domains. And it clearly announces for the first time that American commercial space is the backbone of it all. It is the backbone of NASA's activities, is of course the backbone of our private commercial activities, but also an important contributor to the military domain. So that is an important consideration as we go through, the rest of the laws. And so next slide, please. So I mentioned, hey, what do you do? If you want to launch something to space, what do? You have to go to a number of different places. So launch and reentry, that's the FAA. Before you launch, you have to have a reentry license. If you don't have it and you don't get it, you either can't launch to begin with, or you're going to stay up in space for a very long time. Also, the FCC, if you want to communicate back to Earth, you need radio frequency. At least right now, there are other ideas being batted around, but right now you need radio frequency. There's limited bands for that. You have to get that frequency. If you want to do some kind of remote sensing, take pictures from space of Earth, you have to get a license from NOAA. So, and then there's also the Office of Space Commerce, which is just working on some kind of mission authorization framework so that it can be the clearinghouse for all of these agencies to help facilitate these licenses so that commercial space companies can kind of, get going and get their things launched and be part of the space race. The other so that's an important part of this. The other part that isn't on this that often comes into play and is super important for space companies are the ITAR and the EAR. So anything having to do with national security, who we sell it to, who we share it with, all of these regulations. International Traffic in Arms Regulations is the long name for ITAR. It controls satellites, various components, rocket engines. So there are a lot of compliance requirements that American companies must meet to satisfy ITAR. And there's very significant fines if they don't meet that. And the Export Administration Regulations, or EAR, are also very stringent. So this is on top of these licenses that they need to operate. So I'll just say there's a Full Employment Act for lawyers here. Next slide. For the litigators, I wanted to make sure that I also covered, hey, what kind of things could we be doing in our own domestic courts with regard to space law? I talked about the Canada-Russia claim in the International Claims Commission, but what kind of domestic cases could potentially come up in this regard? And obviously, most likely they would be in federal court. This is, I will say, this is true if there is not an arbitration provision that already applies, or some kind of waiver of liability. Like our space tourism companies largely at this point have liability waivers with their passengers. Those who go up in Blue Origin, those passengers have waived a lot. And if they haven't waived it, then there's usually an arbitration provision. But let's say, putting arbitration aside, federal court's probably where you're going to be. You're going to have, potentially different companies, different agencies. So I want to give a couple of examples. What would these look like? So one of them we have right here in the Central District of California, the SpaceX versus California Coastal Commission lawsuit. This is out of SpaceX's increased launches of Falcon 9s out of Vandenberg Space Force Base on the central coast of California. The military had actually asked for increased launches because actually we are needing not only more launch cadence, but we need more spaceports, more places to launch things. So the ones that we have, we want to use them to the maximum ability. So the Space Force was totally on board with this increase in launch. SpaceX, of course, was happy to have an increase in launch. It's more commercial value to them. But the California Coastal Commission put the brakes on it, saying, no, we're very worried about impacts on the environment, this increased cadence, the noise. Oh, and by the way, they said some very unfortunate things about how much they, as a political matter, disliked Elon Musk. And perhaps that was one of the reasons that they denied this permit. So Governor Newsom said, hey, probably wasn't a good idea to say by the commission. And as a result, SpaceX sued the commission. And the lawsuit really shows, which was recently settled, by the way, really shows the interaction of policy, national security, and state law, sort of the interaction of all of that. So the California Coastal Commission says, hey, we have a right to evaluate environmental impacts, and we have this job to do. But there's also federal environmental laws and federal environmental impacts that the Space Force was required to do in order to allow these particular launches. They did that. They concluded that there was not, it satisfied federal environmental laws to increase these launches. And so long as that was done properly, the California Coastal Commission and the state environmental laws really cannot override that. That's how our environmental statutes are set up. So, so we have that issue here of how much more, should the Coastal Commission really have been able to do. But within the lawsuit, there was a whole bunch of pointing to the Space Force. Okay, the U.S. Space Force wants us to do this. The implication is that are national security reasons to do this. We have a national space policy that fosters and favors commercial space activities. So again, we have another national policy that is on the commercial space company's side. And again, that's against the California Coastal Commission. And so it was really kind of an uphill battle for the California Coastal Commission. And particularly given the policy of the state itself now, Governor Newsom is wanting to actually expand Vandenberg and its ability to launch, recognizing the economic value that provides to California and that there's a dearth of these places to launch right now. So he's got a policy favoring more launches out of Vandenberg also. So I think all of these policies converge together with this lawsuit. and it was settled short of a summary judgment motion a couple of weeks ago, with the Coastal Commission writing a letter of apology to Elon Musk and SpaceX for the things that they said in denying the license. And also the Coastal Commission agreed that within a certain area where they already launch right now, they can increase this cadence. There will be no more interference from the Coastal Commission. But that is a very interesting case. There's also some environmental law challenges to the launches by SpaceX in Bolsa Chica in Texas. So this environmental impact question is one where these cases will come up right now. The other area is regulatory challenges, right? Like challenging the granting or denial of a license. Those who bid for something and somebody else got the bid, having bid challenges. If Blue Origin and SpaceX went up for a bid, a government bid, and one of them got it, one of them didn't, that's how it goes. The loser of the bid might challenge the grant to the other. And then also this licensing and regulatory question. I'll say the American Space Law Foundation had the first American space law in the court this past year in Washington, D.C., and the problem was a D.C. Circuit appeal challenging the FCC denial of a conditional license for an AI navigated satellite that ended up crashing into an Italian satellite, sending thousands of shards of debris back to Earth and also destroying this Italian satellite. So the question was, did the FCC appropriately withdraw that license? And in doing so, could it rely on international law or standards in doing so? So that was a moot court problem, but is a very real kind of question that could come up given the kind of activities in space. So next slide, please. I wanted to address briefly some of sort of the key topics. If you want to, have a good cocktail party conversation and talk about sort of some of the areas where space law is developing and where some of the principles that I've talked about could be worked out, these are some of them. So I've mentioned this orbital debris and space sustainability. There are many, many satellites around Earth. There are even more of these mega constellation satellites like SpaceX and Amazon are lofting out into space and getting licenses to do so. There are many, many small satellites all working together. And so each satellite, each object that goes up into relatively crowded lower Earth orbit creates the possibility of debris. And this question of orbital debris, space sustainability, how do we make sure that, just the smallest piece of a space object, like maybe even a bullet-sized piece of a satellite that survives a collision, that small piece of satellite can completely destroy another space object. Because of the physics of space, you don't need a big object to hit you to create serious problems for others' objects in space. And so this question of orbital debris and we'll say space sustainability, which means can we continue to allow others to launch and maintain their satellites in space without fear of destruction, that is an important question that's being debated at the UN right now. There's actually a space situational awareness group that's working on just fundamentally, like how do we share information? We have these registry of objects, which are somewhat voluntary, but who do we contact? If we think there's going to be a collision, how do we know who to call to avoid that collision? There's a lot of informal ways of doing that right now, but as of today, there really isn't a lot of great options for that or consistent options for that at the international level. Next slide, please. So, oops, yeah, back a couple more. One more, I think. Oh no, one more. There we go. Perfect. Okay. So there are guidelines. There are orbital debris guidelines, as I mentioned, at the international level, sort of best practices for mitigating debris. We're working on having more effective tracking and transparency about our objects. There are some countries that would rather not share that information for national security reasons, what have you. At the international level, we're trying to work out, hey, you don't have to give us a bunch of information, but could you at least give us the basics that our engineers need so that they can extrapolate out whether there's going to be something coming in terms of a collision. And then also in our licensing, actually in our own domestic licensing, if you launch a satellite or you launch a rocket out of the US, in order to get that license, you have to have a plan. You have to have a plan either to extend the life of your satellite or object through in-space efforts, or you have to say, we have a plan when it goes defunct. We're either going to move it up to another level around Earth that isn't as crowded, or we have a plan for controlled re-entry into the Earth atmosphere. So you have to know what you're going to do with your object before you can launch it. Right now, that was not so previously. Okay, next slide. So I've mentioned space mining already. I'm not going to beat this too much more, but the question of governance frameworks for space resources, actually there was an informal independent international group called the Hague Institute that created some building blocks for an international framework for space resource activities. But right now at the UN COPIUS, there is a working group on space resources setting out guidelines that will cover space resource activities. It's been hammered out and debated over the last few sessions of COPIUS, the legal subcommittee and other meetings, and we'll be discussing them again in June. But we're moving towards having some kind of overarching view of space resources. And there's still that debate between, who views it correct under international law to maintain the resources you get, and who see that as incorrect. But we're still working, despite that difference in views on that. It's still having our Artemis Accords and the various signatories to that signing on to this resource extraction principle, together with Japan and Luxembourg having laws around space resources. There is, a very different view being created and socialized about space resource activities. Okay, next slide. The other part, and sort of the flip side of space resources, which actually has been discussed in tandem with space resource principles, oddly enough, is this cultural heritage protection question. So there are no, unlike on Earth, where we protect our UNESCO sites and our heritage, or at least we try to, we have instruments that say we protect them. There is no international treaty protecting space cultural heritage, like Neil Armstrong's boot prints, like many of the other firsts that have occurred on the lunar surface by other countries and private actors. And so if somebody decided to just want to come up and, sort of start mining something under, Neil's boot prints, theoretically, at least legally, they could, although the US has called out and said, no, we believe we want to protect that, and we think we have the right to do that. But still, there is no international instrument for that. But the Artemis Accords do recognize the importance of cultural heritage protection. And so that is quite a number of countries that recognize that. And then, as I mentioned, in the Space Resources Working Group, there's been some discussion of safety zones and of efforts to protect cultural heritage along with space resources opportunities. So, you're not going to mine under the Apollo lander, but that that's in flux in terms of the space resources discussion. But this is an important thing to pay attention to. In your materials, there's actually an article of mine in the Space Law Journal talking about setting up a commission for the protection of cultural heritage as a potential option to preserve it. All right, next slide. The other question that's being debated right now, and which is real, is this in-space assembly and manufacturing. As I said, one of the ways to extend the life of a satellite is to repair it in space. And so there's companies that do that. And also just other kinds of novel in-space assembly and manufacturing, having gas stations in space, having other kinds of manufacturing in space. As I mentioned, there's obviously drug pharmaceutical manufacturing that's been going on in part in space also. But this is the infrastructure building of space. And so this is one of the novel space activities areas that really isn't currently regulated or licensed by any particular agency, although the Office of Space Commerce is taking ownership of it and will look to this in the future. But all of this question of allowing it, but having some kind of regulatory oversight is important. All right, next slide. This is also another question coming up from the increase of satellites, the increased launch satellites and the increase of density of satellites through the satellite constellations. So just as, it's nice and beneficial to those on Earth to have the access to the internet and to technology that these constellations provide, which provide internet and phone access to remote regions of the Earth, there's still a concern that from our standpoint here on Earth, that our astronomers who are studying space and are studying the stars are impaired in doing so by the brightness of these constellations. And so this question of how do we balance the commercial space and the constellations with our own scientific research on Earth with regard to the stars and space, and developing international guidelines surrounding protection for this. In the meantime, I will say that sometimes we can solve things with technology. And so those who have these concerns have been talking with some of the commercial companies and trying to work out, are there ways that you can adjust the lighting or the turning on or turning off of certain satellites in your constellation that can interfere less with our activities as astronomers on Earth. And so they've sort of tried to use technology to do that. All right, next slide. So just to wrap up, at least the formal presentation. So as we continue to go out and move out into space, obviously things are in flux, the activities are in flux, the law either is in flux, I think that's a charitable way of putting it. The law in many ways has not contemplated some of these activities, or maybe did so generally, but hasn't figured out what kind of governance or principles to apply. And so what I say today could change tomorrow to some degree based on where our policies and laws are going. But as of today, in 2026, this is where we're at in terms of space law. And last slide, I just want to give you a couple of resources if you're interested. I have two different podcasts. The Cosmic Council podcast is a short, limited edition run podcast involving some of these debates where we have experts come on and debate, who can own the moon, how do we balance commercial protection of space exploration and still maintain cultural heritage. Things like that are debated in a discrete number of episodes on Cosmic Council. And then the Portia Project podcast features many of the leaders in space law and activities, whether they're general counsel of space companies or space agencies or the UN. So if you're interested in learning more about, what they do and how they do it, you might check out the Portia Project as well. So thank you so much for being here and for learning Space Law 101. Really appreciate your being here. I didn't see Q&As, but I want to make sure I didn't see any questions. Oh, here we go. has a state tried to enforce provisions of the liability convention? Yes, I think I mentioned that Canada had done that against Russia and successfully got a settlement. So yes, tested it in terms of filing a claim. Has the commission ever actually stood up and become operational? No. Okay. All right. Well, thank you so much. Thank you to the Beverly Hills Bar Association for holding this program and for, sharing the what I find interesting at least, which is space law and policy. And I'll just say that all of you will become space lawyers at some point or the other, given the huge commercial value of space activities. So there will be you may have a need for these treaties in a way that you can't possibly fathom at this point. So I hope you find value in this in your practice in the future.